mother's attorney seeking some kind of visitation relief. Let's see. Foster parents, the Lowrys are here. The mother, Tatiana Brown, is here. Her attorney, Ms. Evans Battle. I don't see Mr. Murray here, but Mr. Murray's lawyer, Ms. Crane, is here. The case manager, Ms. Williams, department's attorney. I don't know. He's in the waiting room. Supervisor, Ms. Long. Supervisor, Ms. Ishmael. Ms. Rock, the guardian ad litem attorney for the child. And Ms. Williams, what is Ms. Brown's current visitation schedule?
She currently visits with Shit Christian every Friday afternoon. Well, they start in the morning. She recently asked if she could have visitation start a little later, but we said that she has to stick to the plan, so 9 to 5.
9 to 5 every Friday.
Correct.
The child, and those take place at her house.
Not even 9 to 5 is 9 to 7.
I hear some background noise. I don't know if they were.
Sorry, I was saying 9 to 4. It's 9 to 4.
Okay. All right. According to the motion, the mother asked for a visit on Easter Sunday, and y'all said no. What is that
Correct.
about?
She has not had a drug screen since January. She has had several attempts from the drug screener to come out and collect screens back on February 7th, February 8th, February 21st, March 15th, and March 19th, and she has not been tested since January 4th.
Okay. Well, get her tested. I don't.
Correct. However, we have sent the tester out there on multiple occasions, and she has missed the appointments each time. Usually, sometimes it's because she's not at the residence, but, on several occasions when the screener has texted her, she says she's not available. So, she was screened on 104, and she was positive for cannabis on that screen. She did an oral and a urine. The oral was negative. The urine was positive.
I should point out for the court as well, Judge, Ms. Williams just recently took this case over from Ms. Brownlee, who's no longer with Henry County DFACS.
Judge, if I may, her current visitation schedule was set by the court. She visits on Tuesdays, every other Tuesday, and on Fridays is her current unsupervised visitation schedule.
What's the visit on? You say every other Tuesday?
Yes, sir.
What is that? What is the time of that?
It's the same time from 9 to 4. It's supposed to be.
Okay. Ms. Williams, were you not aware of that extra day?
I was aware of the extra day. It slipped my mind. I apologize.
Okay. We've gone almost 2 months with no drug screens. That's not good.
Judge, that's not accurate either. My client, we were at a hearing on February the 13th, and the department reported at that time she had taken a drug screen on February the 6th. So it's been less than that time period. And if the court would recall too, the concern about the drug screens, my client, and it's in the last court order in regards to her having a death in the family, and the inability to schedule on time. So they did get one on February the 6th. And it's my understanding that my client has been in contact with the drug screener and Ms. Brownlee when she was here in reference to the reasons she would not test. I have a copy of the text messages between Ms. Brownlee and Ms. I'm sorry, it's Miss Julie, is my understanding, is the drug screener. I don't know if there was a man before then.
Your Honor, I asked the department about that. The department indicates that that may have been an error in the order from February. They have checked and they do not have a drug screen that was done on February 6th. So the only drug screen that the department has, and having checked, was, as Ms. Williams indicated, back on, I believe it was the 4th of January of this year. So in the last 3 months, that is the only drug screen that we have at this point. And the drug screener has provided with the department with a number of explanations. We were hoping she would be on this Zoom call, but she had a doctor's appointment this morning. It is more than what Ms. Williams and Ms. Battle has indicated. It's not just that they've not been able to schedule the screens, that there was at least one occasion where the screener was at the home and the mother was at the home. The mother walked out of the home and said, "I don't have time to screen," and didn't submit to a screen. So it's been more than just scheduling issues.
Well, and our position is that, there are other ways in which the department could handle that situation if she's not screening, other than denial of visits. That is something that affects the child as well as this affects the mother.
We're not denying a visit. It's not being denied. She's still getting her Friday and Tuesday visits.
And, but two, the relationship between, the parent and the child, and the ability of the mother to integrate the child back into the family is important just as well. Some accommodations ought to be made and not be a matter of punishing anybody for, and then in this instance, there's a remedy. There's a way in which the punishment could take place, because they could bring, they could file a contempt and bring it back before the court for those actions. We make accommodations all the time when it comes to ensuring that if the family there's a reunification plan, that we move forward and doing all that we can. And I don't think it's unreasonable for her to ask for one day outside of that.
And just to respond to Ms. Battle, Your Honor, if you allow me, if you don't want me to, or Ms. Long can speak to the number of accommodations that the department has made for Ms. Brown, despite her not abiding by the court's order that she submit to drug screens. There's been several accommodations that have been made with regards to transportation issues that the mother has alleged, that she was bringing the child back from visits rather than bringing the child back to daycare, wanted to drop the child off with the Lowrys, things of that nature.
Ms. Schrock, do you have any questions for the case manager or the mother?
So with her scheduled visits, is the child being transported by a transporter for these visits?
No, right now Miss Brown is transporting the child. She's getting the child.
Okay. I don't have any other questions.
All right. Anything else?
Your Honor, I just asked, let me ask Ms. Long a couple of questions, and then that way just he's more conversant to what the department has done with regards to accommodating the mother. If the court wants to hear that, I'll be glad to put that up. It wouldn't take but 5 minutes.
Sure, go ahead.
All right, Ms. Long, raise your right. Yeah, I think you were already sworn, so go ahead and unmute your microphone. State your name for the record.
Brandy Willis Long.
And Ms. Long, are you currently a supervisor for a foster care unit at Henry County DFACS?
Yes, sir.
All right. And have you been the supervisor for that child in the last since the child has been in foster care?
Yes, I have.
All right. And previously, the case manager for the child was Ms. Brownlee, correct?
That is correct.
All right. And when did Ms. Williams take over this case from Ms. Brownlee?
March 18th.
Okay. So
of 2024.
Just about a week ago?
Yes.
All right. And are you familiar with this case and with the mother, Ms. Brown?
Yes.
All right. Would you tell the court just briefly, first of all, I know that in January that the department had a conversation with Ms. Brown about her having wanting to bring the child back from visitation to the Lowry to the Lowrys rather than foster back to the daycare. Would you just briefly discuss that conversation with Ms. Brown?
Yes. There was a conversation had with Ms. Brown and Ms. Brownlee. They could not resolve. And so they then reached out to me, where Ms. Brown stated that because the child had moved daycares, that it was too far for her. So she would prefer to transport the child back to the Lowry's home instead of back to the daycare. However, at that time, I told her we would not be making any modifications because we needed to stick to the schedule. And at that time, Ms. Lowry was not comfortable with her doing that because she there was a certain time that she picked the child up from daycare. And so, that would interrupt with the other things that she had to do. So we told her no, that she needed to figure out a way to transport the child back to his daycare instead of to their home.
What other accommodations has the department made for Ms. Brown and her visitation with the child? I know there have been some discussions when we stopped this case last week, just to refresh the recollection, kind of what I'm getting at is about Ms. Brown cutting some of these visits short because of transportation issues that she was saying she was having.
Yes, because I believe she transported this child by Uber, and she has made comments that it had become too expensive or that, like I said, the daycare was too far. And then I'll go back to we just did a special visit for her sister or her friend's funeral. I don't know which one, but I don't want to say the wrong thing. But Sha Christian just attended a funeral with her a few weeks ago. And then also we made, we didn't make the special accommodations. We had made a schedule for the Christmas visit, and we had agreed upon times and whatnot. However, mom still showed up to the foster parents' home earlier than agreed upon, and she informed the foster parents that Miss Jasmine was already aware and that we had agreed to the time change, which we did not.
Okay. And then what about, was there recently, with regards to Ms. Brown having requested that the child be able to attend a funeral?
Yes, I just spoke about that.
Okay,
And we did make accommodations for him to I'm sorry. We did make accommodations for him to be able to attend that funeral.
Is there anything else other than what you've spoken about up till now as far as accommodations that the department has made for Ms. Brown with regards to her visitation?
I just would like to say that it is always, every so often she will call and try to make changes to the time or how late she can keep him or how early she can pick him up. This is not the first time. She has reached out to Miss Alicia since she has been on the case asking for accommodations to push the visitation back, which would mean that the child would be returning back to the foster home later. I just feel like I'm not trying to interrupt the visits that she has already had, but to basically reward her with something extra when she is not cooperating and doing what she is supposed to do is just out of the question. Foster parents can attest to the incidences that they have encountered with her. She has a habit of calling them and stating, well, do you guys have anything to do? Is it okay with you? And then before even reaching out to us to get permission. And that is an issue as well. But they can attest to their experiences with her.
Nothing else from Ms. Willis. I mean, Ms. Long, Your Honor. I'm sorry.
I was muted. I asked, were there any other questions?
I just have a question, Judge. From your testimony, the only actual special visit that the department made without court approval was for the sister's funeral, correct?
Yes, because for the visit for Christmas, she did that herself and then stated that we were okay with it, and we were not.
Okay, but the court allowed the visitation for Christmas. Is that not correct?
What do you mean the court allowed it?
The court, she asked the court if she could have the visit for Christmas.
She had a special visit for Christmas. However, we agreed upon a time, and she showed up to the foster parents' home earlier than agreed upon, stating that the department gave her permission and that we were okay with it, and we were not.
Okay. So the only accommodation that the department made on its own was for the funeral. Because all the other accommodations you said no, correct?
Yes.
Thank you.
All right, the request for Easter visit is denied.
Judge, my client had her hand up. She wanted to
well,
provide some input.
Go ahead.
Hey, I just wanted to voice something before you made your decision on the visitation, why I was requesting to change my visitation, because I I'm still working at Fresh Express. I was trying to change over to morning shift, well, better shift that fit my time framing for my situation of what I have going on now. That was why I had asked to change my visitation prior to her testimony. And as far as no, she said something else about when I asked to change the timing from picking him up from the daycare, from dropping him off to Miss Laurie's residence, I only asked to do that because the expenses of Uber, I had took Uber that day, and me taking him to the daycare and then trying to make it all the way back up the road to my job, it was a little too expensive for me. No, I don't always take Uber because I have someone that normally help me transport my son, but she was not available. I had to compromise. She had a doctor's appointment that day, so it's not always that I take Uber.
Okay. All right, thank you. All right, the special Easter visit.
And Judge, can I ask her about the drug screen? Did you actually take a drug screen on February the 6th, as alleged in the prior hearing by the department?
I did take a drug screening in February. As far as the drug screening for this month, I have messages. The drug screener contacted me on the day before I had court for probation. She advised me that she was going to meet me up at the courthouse when I was in violation of my probation. So I did not feel comfortable. That was okay for me to be rushing to go to court and do a drug screening and then go in the court for my probation. I was already running late Uber, you know what I'm saying? So that was the reason of why I did not take my drug screening for this month. I have messages where I advised her I was free any time of that week if she wanted to come by, and she never contacted me back within that week.
And did you provide me with the text messages from the screener and Ms. Brownlee?
Yes, ma'am.
And if I can share my screen, Judge, just to be able to show the court messages that she has. The way that I uploaded them, they're kind of out of order, but I can just go through them real quickly. It's only 5 messages. And they are from January until, I'm not really technologically inclined right here, but can everyone see the message? And then this message from February the 7th. It looks like February the 7th and 8th. And they asked for a screen and you were not able to screen because you were attempting to help plan your funeral for your sister, correct?
Yes, ma'am, correct. And then after that, I had a visit. Miss Brownlee came and did her monthly with me, and she didn't tell me, but she brought the drug screener with her, and I did a drug screening on that exact same day of my monthly visit.
Okay. And that would have been when?
February.
But you don't know what day it was?
No.
Okay. And This is a message with, it says caseworker Brownlee. Is that correct?
Yes, ma'am.
Okay. And this is the February 6th visit that you were talking about, which you screened with her.
Right. Okay, so right here where it says, but I'm going to be moving soon. And then I said, I'm inside. And she said, we outside. That was the day that she came over for her monthly visit, and I actually brought this drug screener with her.
Okay. This chronic looking card, like you see the date, February the 6th. That's alleged, and Miss Brownlee had previously alleged that she had actually drug screened you, correct?
Yes, ma'am. Bam.
And then you have some current messages from the drug screener. Looks like this may be the first. This may be the first one. And this is with a new drug screener.
This is the same lady, Julia. I think that's her name. But this is the same lady that's been drug screening me since this year.
Okay, Miss Julie.
Yes, ma'am.
Okay. And that was the one that you
and this is the message when she contacted me on March the 14th. She asked me, could I please come to Henry County DFAC's office at 12:30 to proceed in the drug screening. I had just awoken. I told her, unfortunately, I had just woke up about 30 minutes ago. I had fed, changed my daughter, and, opened my phone and seen it. So I advised her that I could not come up there to Henry County to do the drug screening because I did not have a ride. But I also advised her that I could come tomorrow morning because I had to go pick up my son if she could have met me there. She said, nobody will be there to drug screen you tomorrow morning. I said, well, will Tuesday work? And I said, who is this, by the way? She said, I will get back with you next week. She said, I will get back with you next week. I had a drug screening in the office today. So, even if I do miss it, I still give her another day or another time to try to accommodate me missing the drug screening. Hold on, I'm gonna give her to my aunt.
Okay, and so you did, it appears in the next message, indicate that drug screener, that you could, that you could make the accommodation for next week as she suggested, correct?
Right. She contacted me on the day before this was
the 14th. Okay. I'm sorry, that's the 14th of March.
Okay, right. She said, okay, I'll get with her and let her know what time is court. Okay, she contacted me and asked me, could she do a drug screening next week? I advised her Monday I have court and I will be available next week. I just could not do Monday. So she asked me, could she come to the courthouse to do the drug screening? And I told her no.
The messages. I'm going to submit them to the court. And then the final one is the continuation of that conversation when you indicated that you would make yourself available. Correct?
Say that one more time.
And there was a continuation of the conversation in which you indicated that you could make yourself available.
Right. I told her I will be available anytime after that week. I also called the new caseworker. I also called her. I have a witness that could attest to that I called her and advised her that I did not want to do a drug screening while I had court. I am so sorry. Give me 1 second. Bell.
Judge, I would just ask that we be able to submit
What did you ask?
I asked to be able to, I guess, tender those and those 5.
Any objection? Any objection?
No objection.
I couldn't hear a word that was basically being said during any of that. What is she doing, Your Honor, trying to tender those?
I'm just tendering those.
Screenshots of.
I don't object, Your Honor.
I have the documentation that we've received from the screener, Your Honor, which is obviously not in. It's very difficult for me to have seen any of that and all of that. So, I'll leave that up to the court's discretion. I think that the court needs to hear then from the department as to the information that the screener provided to them.
None of this makes any difference about ruling on the Easter visit. I'm denying the Easter visit. She's got more than ample unsupervised visits. The child is under 3 years of age. She can have an Easter egg hunt for him on her Good Friday visit this Friday, and he won't know the difference between Easter Sunday and Easter Good Friday. That has nothing to do with, now I'm getting ready to tell you what I'm going to do about the lack of drug screens, but that's, to me, separate and apart from the Easter visit. Okay? So if you still want me to hear something else, keep going. Is there something else?
Are you talking to me or to Miss Battle?
No, no, Judge.
You wanted to hear something.
There's nothing else in relationship to that, but I will just, I know the court is upset about the drug screens, but I would ask the court to be mindful.
I'm not denying the Easter, but yeah, based on the drug screens, I'm denying the Easter because we don't need an Easter with a 3-year-old kid. It doesn't make a bit of difference.
I think he's older than 3, Judge.
No.
3?
3. He'll be 4 in December.
Okay.
Unless I've got the wrong birth date. She's got more visits than just about anybody on my caseload right now, unsupervised. So, and I'm not knocking it, but we're going to make some adjustments if we don't get this drug screen stuff turned around. The only question I have is for Mr. Lowry, or whichever one of you wants to speak for you as the couple, the foster parents. I'd heard testimony that you at one point in time may have been reluctant to have contact with the mother. It sounds like she's having contact whether you want it or not. I don't know whether you want it, but is the contact you're having with her okay with you?
She contacts Miss Lowry. As far as the contact with me is to know our last conversation was she sent a text message saying that she didn't want anything to do with us and all communications will go through DFAX.
Okay, so she's no longer coming to the house
no,
earlier than scheduled or later than scheduled or anything. Okay, that's because
we initially, like I said, during the Christmas time, she came and told us that it was okay for it to happen, and it wasn't. And after we found out, we made it abundantly clear that if we didn't get a conversation from DFAX, then we were sticking to the schedule, because if you're telling me that you got 2 hours earlier and you don't, are you allowed to bring him 2 hours later and you weren't supposed to? We're not taking those chances.
Okay. All right. So she's not communicating with y'all or coming to your house to pick up or retrieve the child?
No.
Return the child?
At least not with me.
Well, how about with Ms. Lowry?
I think she does cordial conversations, like send her pictures or videos of Shakrishan doing events, things like that. But I'll let her speak on that.
Well, she did come to the house for the when they modified the visit for the funeral.
Okay.
We did let her come to pick him up because there were I don't think there was any school or anything. So she came to the house to pick him up and drop him off. And that's it.
All right. Okay. So are you okay with Miss Brown having telephone contact with you, Miss Lowry?
I have no problem with her with talking to her, but the thing is, anything about defects, we basically talk about the children or CJ.
Okay, that's
things,
good.
Other than that, that's it. That's about as far as we go.
Okay. Yeah. What about is she coming to the house to pick up or return the child anymore?
No, sir. Just for the funeral.
Right,
that was the only time.
Okay, then I don't need to. I'm fine. If y'all are fine, I'm fine, and I'm going to leave that like it is. As to the drug screens, Miss Brown, we will never get to a conclusion of this case without regular drug screens. 3 months without one is not acceptable. I'm not blaming you. I'm blaming the department partly, and I'm blaming you some, because it sounds like at least one time you didn't make yourself available, and you could have gone in the bathroom in the courthouse. Nobody would have known anything, but you didn't do it. The bottom line is, and the department knows this, and I'm fussing at them, and I'm sorry you had a change in staff, and that may have had something to do. And I've told you umpteen times, you're responsible for the vendors you get, and if they're not worth a toot and they don't do what they're supposed to do, you're on the hook for it. Now, random drug screens does not mean you call mom on Friday and she says, I'm busy, I can meet with you next Tuesday. That is not a random drug screen, Ms. Brown. You're manipulating when you give the sample, which could mean you're manipulating the results intentionally so that you'll be clean by the time they get to you. You don't get to do that. I expect you to test within 24 hours of when they say they want a sample, and you have to make yourself available, whether it's at midnight at your house or whenever they can get there. And these testers, de facto, you're responsible for making sure they understand that you've got to get these tests on a regular basis, on a random basis, and a consistent basis. So we're going to come back in 3 weeks on April 16th at 2:00, and you better have a drug screen on this lady, and it better be negative, Ms. Brown, as to all substances, or we're going to revisit the visitation schedule. Right now, visitation stays just like it is. But it's inexcusable that we've gone 3 months with no visit, with no drug screens. And Mom, that's not all on you, but it sounds to me like there were 2 that you could have tested and didn't. So remember that. I will see y'all back on April 16th at 2:00. Do y'all want to do that live or on Zoom? All right. Did we get drug screens?
Yeah. Can you give me 1 second? Ms. Crane is asking for the link, Your Honor.
Oh, tell her we'll let her know the results. Go ahead, Mr. Scaroni.
So you had asked about the drug screens. We actually did get some drug screens for the mother, which I sent to counsel last week, I believe it was. The mother underwent a urine and an oral hair and a hair follicle screen on April 2nd of this year. She was negative on her urine and on her oral, and her hair follicle was positive for THC, benzos, and cocaine. So that is the extent of the drug screens that the court was asking about. And I do have some testimony that I was going to have Ms. Williams put up as well, based on her conversations with Ms. Brown from last week, some text messages and things of that nature.
Do you need this gentleman who's a certified addiction counselor? Did you need his testimony? If you do, can you take him first so he can?
Wasn't aware that he was going to be here, Your Honor. I think that based on what Ms. Williams and I had discussed during staffing last week and whatever, I think that we're probably okay to move forward without him.
Well, you're going to hurt his feelings.
I'm not sure. And I don't, did you ask him to come, or did Ms. Brown ask him to be present? Do you know?
Mr. Cannon, did the mother ask you to be present?
No, the case manager asked me to be present.
Okay. All right. Well, you're under oath. Is there something you want to share with us about this case before we excuse you, since the defense lawyer said he was going to elicit probably the same or similar testimony from Ms. Williams? But if there's anything you want to share, since you've taken the time and trouble to be here, I'm glad to hear.
Ms. Brown at first was very positive with her substance abuse treatment. That's when she was bedbound with her baby, where I worked with her. Then after that, I kind of seen a little short change of personality afterwards. I think that happened because of her unstable home environment that contributed to this drug use. And then also her occupation going back into the club environment working also brought up some risk factors. We did talk about external and internal triggers and how those things can impact. And I think that she has allowed her circumstances to cause her to relapse.
Mm-hmm. All right. Anybody have any questions for Mr. Cannon?
Mr. Cannon, are you currently seeing Ms. Brown and for substance abuse counseling?
I was seeing her. We was kind of entering up toward the end of this month with the previous case manager. The goal plan was to actually discharge her at this month. She's on a taper down part of the substance abuse treatment, but with this recent relapse, then I would recommend her to actually do probably a SAM level 1, where we was just doing really substance abuse education at first because she was pregnant and homebound. But now, since she's out and about back in the community, dealing with those same environmental factors, she needs more of a stronger structure program.
So just so I'm clear, you were doing something less than an ASAM level 1?
Right. We was doing substance abuse education because she was bedridden at the time. She was having her baby. And then from there, we started doing aftercare, which was 1 time a week up to we're doing 2 times a week, versus if she was doing AMSAM level 1, she would be doing 6 hours a week plus an AABD and regular drug testing on a regular basis.
Okay.
Almost like an intensive outpatient service.
Okay. So again, just to be clear, the services that you were providing up until now were lower than an ASAM level 1 treatment program would be, correct?
Correct, because she has already completed that coursework for that, which was Matrix that I was using. She did a relapse prevention piece, the relapse classes.
No other questions for him from me, Your Honor.
Okay. Thank you so much for sharing that with us, sir. We can excuse you now. Appreciate it.
Okay. No problem. Bye-bye.
Bye. All right. All right, Ms. Williams, I think it somehow in there left and came back. So if you said you wanted to ask her something.
Yes. So Ms. Williams, you can unmute yourself there.
Yes.
State your name for the record.
Alicia Marie Williams.
Where are you employed?
Henry County DFACS.
What do you do for the department?
I'm a social service case manager for foster
And the
care.
mother of the child is Ms. Tatiana Brown.
I'm sorry, Mr. Murray was calling me, so I couldn't hear you on audio.
That's no problem. The mother of that child is Tatiana Brown, correct?
Correct.
And the biological father of the child is Mr. Isaiah Murray?
Correct.
We were last in court on this case on March 27th of 2024, based, I believe it was on the mother's motion to have Easter visitation, which the court denied, and then wanted some drug screens. You heard my report to the court, but just for purposes of clarification, did the department get drug screens, both urine, oral, and hair follicle screens from Ms. Tatiana Brown on April 2nd of 2024?
Yes.
All right. And her urine and her oral screens were negative for any controlled substances. Is that correct?
Correct.
What about her hair follicle?
Her hair follicle was positive for cannabis, 2 different types, as well as cocaine and benzos.
And when did you receive that report from the hair follicle drug screen?
The hair follicle came back on 4/11, but it was not reviewed till the morning of 4/12.
Okay. After you reviewed the drug screen results from the hair follicle on April 12th of 2024, did you reach out to the mother, Ms. Tatiana Brown, about the results of that drug screen?
I did.
And did you discuss those results with her?
I did.
And what, if anything, did the mother disclose to you about the results of her drug screen?
She first disclosed to me that the results could have been positive for cocaine because she was having unprotected sex with the father of Isabella, her newest child. And then I discussed that the levels were in the 5,000s. And then she noted to me that she had to be honest. Her baby's father is cooking crack cocaine in the home. And it's possible that due to him cooking this in the open area of the kitchen, it got into her system.
Okay. As a result of that information, are you aware as to whether or not Clayton County DFACS took action to remove Ms. Tatiana Brown's youngest child from the home?
Yes, sir. I was contacted by a case manager from Clayton County DFACS on the 12th, that Friday in the afternoon, noting that she was going out to assess Ms. Brown's home.
Yeah. And were you advised at some point in time that the department in Clayton County took custody of Christian's half-sibling, Isabella?
Yes, sir.
When were you advised of that?
5 p.m. on the 12th, Friday.
Okay. So the child was removed on Friday the 12th?
Yes, sir.
And what was the reason that Clayton County removed that child from the home?
Due to the father of Isabella not wanting to do a urine specimen, and also just due to the history with the mother and her not being able to screen for long periods of time, and then this last positive drug screen along with the information she provided to me, they felt that Isabella should be removed from the home for her safety.
And the mother and Isabella and that child's father were residing in
Somebody's needs to mute their mic. I'm hearing background something. Go ahead. I'm sorry.
So, the child, the mother, and the biological father were living in Clayton County, correct?
This is correct.
Okay. And after the child, Isabella, was taken into custody in Clayton County, did you have some further contact with the mother, Tatiana Brown, wherein she advised you that she was immediately moving?
I did, and I asked for a said lease and was not provided one.
Okay, so let's go back. What did Ms. Brown tell you? What did she say? I'm moving, I'm going somewhere. Did she give you a reason? That's what I'm asking.
She did not give me a reason. She said that she has been planning to move for quite some time and that she would be moving this coming week out of the home with her and baby.
Well, you said with her baby. She didn't have her baby, so how would that?
Well, that's the word she said to me. However, obviously, that was just what she said.
Okay. And you said you asked the mother to provide you with a lease or an address for her new residence?
Yes, sir.
And has she done that?
No, sir.
Tell the court, if you would, there were some conversations previously about concerns that the mother was having her current boyfriend, the father of Isabella, Mr. Terry, I believe is how he was referred to. Did you receive some further information as to that individual's identity?
The father of Isabella, Mr. Danny. That's
okay.
yes,
What is his name?
Danny, I would have to search for the last name in my notes.
Are you aware of that individual having previous Child Protective Services history with the Department of Family and Children's Services?
Not to my knowledge. However, he would not cooperate with us to submit to a live scan or a urine screen.
Okay.
So we haven't ran anything on him.
Did you have any contact with the mother since, I guess Friday or Saturday of last week, where she sent you a text message?
Yes, sir. She noted several things in the text message regarding my supervisor, Brandy, and myself, and our intentions to keep her child.
I'm going to see if I can share screen, which I'm not that. Here we go. And can everyone see that?
I don't think I can get close enough to the screen to read it, but I can see it.
Okay. Well, I'll have Ms.
I can see it now. I've gotten closer. I'm like 2 inches from the screen.
You should be able to zoom in on it too, Your Honor. But so Ms. Williams, this text message that I just put up on the share screen, is that a text message that you received from Ms. Tatiana Brown?
Yes, sir.
And when did you receive that?
I received this early Sunday morning around 4:58 a.m.
And how do you know that that was from Ms. Tatiana Brown?
Because this is the number that we correspond from quite frequently.
Okay. And if you would just read that out so that the court, if Judge Bartles is having any issues reading that.
Okay, I've read it now.
Okay. All right. And Your Honor, unfortunately, due to the traffic tie-ups that were here in Henry County, I just got this text message this morning. I would like the opportunity to take this text message and also the 3 drug screens that I had submitted to counsel, which I can't really share a screen on, as I tender those into evidence. I just couldn't get them over to the courthouse because of the backup in the traffic.
Anybody have any objection to him sending them in at the close of the hearing?
No objection.
Judge, I would ask that she identify the telephone number of this text message before it's submitted.
Okay.
Ms. Williams?
I don't see a phone number.
Yes, sir. I can take another screenshot of this with her name and then the contact as well.
That would be good because you got it's got Brandy on there and you can't read a phone number or anything underneath there.
Correct. It was a screenshot. I can take another.
All right. But is this text copy that that I am sharing with the parties currently, is that a true and accurate copy of the text message that you got from Ms. Tatiana Brown on Sunday at approximately 5 a.m. of this month?
It is.
Has this been altered or in any way?
No, sir.
And then with regards to the 3 drug screens that I reported to the court and that I actually submitted to counsel last week, the urine screen, the hair follicle screen, and the oral swab screen, were those copies that you provided to me, which I provided to counsel, true and accurate copies of the drug screen results as to Ms. Tatiana Brown from April 2nd of 2024?
Yes, sir.
And Your Honor, I'm going to be tendering those in as defects exhibits number 1 through 3 for the drug screens, and then it'll be number 4 for the text message.
All right. Anybody have any questions for Ms. Williams?
I actually wasn't done with them, Your Honor.
I'm sorry. I thought.
Ms. Williams, given the statements that were made by Ms. Brown about the unprotected sex as a possible excuse for her positive hair follicle, and her boyfriend cooking crack cocaine in the home, and her positive drug screen on her hair follicle drug screen, is the department asking for a change back to supervised visitation as to Ms. Tatiana Brown at this time?
Yes.
Did you hear from Ms. Brown at all today?
I did not. I did hear from her yesterday evening.
Okay. Did you remind her about court this morning or this afternoon?
Yes, she was aware.
And did she tell you she was planning on attending court?
She sounded like she planned on attending. However, the conversation did not go well.
Okay. Explain that. The conversation did not go well. What does that mean?
My administrator, Miss Ishmael, and I had a 3-way phone conversation with her, trying to discuss visitation for Sir Christian and make sure he could still have his visit today. However, she became very frustrated with both of us and noted she did not wish to have her visit with him today, and she used some profanity, and then we ended the convo.
And when was that visit scheduled to take place?
It was scheduled to take place till today. It was today. We just wanted to have her pick up Sir Christian after court, after the judge reviewed this case.
I don't have any other questions for Ms. Williams, Your Honor.
Anybody have any questions?
No, sir.
I do, Your Honor.
Go ahead.
I'm sorry. I just want to confirm, Ms. Williams, the mother was still going to be allowed to pick up the child today after all of this that you just testified to, or no?
No, we were going to wait until court to see what the decision was going to be, and if we were going to need a supervised transporter to pick up the child, or if there would be a visit period. So we had not decided.
Okay, I'm sorry. I was just confused. Thank you.
Anybody else?
Just briefly, Judge.
Sure.
Just when we'll start back a little bit backwards, but with the visitation issue, did you all tell her last week when she received the negative drug screen, the positive drug screen, that you were going to go ahead and change the visitation to supervised?
We did not tell her that. We were waiting to see what would happen and transpire in court. We had not made any decisions on that yet.
Okay, so she continued to have unsupervised visits until?
Well, the incident occurred on Friday, and she has not seen the child since. So she has not had a visit with the child.
Okay. So you were just giving her the report about the positive screen on Friday?
Correct.
Okay. And then, and it's your testimony that she actually told you that the father was cooking crack in the home?
This is correct.
Then the other thing was, did she provide you with some information regarding prescriptions that she is currently taking?
She did not provide this information. I did ask her for copies of screenshots of the medication or pictures of the actual bottles. She did not have those, and she noted she did not remember the names of the medication in question either.
Okay, and do you recall that we previously in court had talked about her, that she was anticipating moving this month or the end or the beginning of next month?
She did note she should be out by the end of this month.
And so do you know whether or not, do you remember her telling you that she had to meet with the leasing agency today?
I do remember that. She yesterday in court testified that she was meeting with the leasing agency yesterday afternoon. So that should have taken place already.
Do you know whether or not she has spoken with her counselor regarding what's going on with the removal of Isabella and her positive?
With her individual counselor, Miss Amy Phillips, yes, she has spoken with her last Friday as well as Saturday, and she told Miss Phillips she did not want to talk to her Saturday, so they have not spoke since she did not engage in the session.
Okay, and so if she changed her mind and did have a conversation with her. You're not aware of it right now?
I spoke with Miss Amy Phillips 10 minutes prior to court, so unless it's been in the last 10 minutes.
Do you know if do you know whether or not there was any advisement as to whether or not she should attend court because of her frustration and her coping skills her coping skills right now?
On Friday, her and Amy Phillips had a discussion about moving forward and attending both the court hearing yesterday, the 72-hour, which she was present for, and the court hearing today.
Okay. And would you agree that when you look at the text messages, the removal of her child, having to go through all this process, that she may be a little bit frustrated and unable to cope with the situation?
I would agree that it's frustrating. I don't agree with the language in the text or the way it was said.
Thank you.
All right. Anything further from this witness?
No, Your Honor.
Any other witnesses?
Yeah, just briefly from Ms. Long, Your Honor.
All right.
Ms. Long, you've already been sworn, so go ahead and state your name.
Brandy Willis Long.
Ms. Long, are you currently the supervisor for Ms. Williams in this case?
I am.
Tell the court what information you learned about the identity of the father of Isabella, sibling to Christian, that has previously been ordered by this court not to have any contact with Christian.
So we well, first of all, he is not to be present when mom is having her unsupervised visitation with the child in the home. That's first and foremost. However, we did learn that he refers to himself as Terry. However, his real name is actually Danny Ingram. He was involved in another case several years ago, maybe 2016, 17, 18, where one of his biological children entered care, and that child was adopted via that case.
So Mr. Ingram has been he's been the gentleman that's been living with Ms. Brown, and you just recently discovered that he is in fact Danny Ingram, and has had prior CPS history. Was there anything else that you learned about him other than that?
No, sir. He does have an extensive criminal record. Some of it is drug related, but yes, the entire time that Ms. Brownlee was the case manager, he never gave her the name of Danny Ingram. He always referred to himself as Terry. So we discovered, via history, and made the connection and identified that that is who he is. And he also stated his name on yesterday, involving the Clayton County case with Isabella.
And did Mr. Ingram appear at that hearing yesterday in Clayton County? I'm sorry.
Yes, he did.
Okay. All right. That's all I wanted to clarify, Your Honor, is that individual that everybody had been referring to as Mr. Terry is in fact not that's not his name. And
all right. Anything further?
Just a couple about whatever relationship Mr. Ingram or Terry would have in this case, but I don't know if the court recalls or if Ms. Long recalls Ms. Brownlee. Think of the lady's name. The person who, I'm not Ms. Brownlee, but Ms. Jasmine, who was allowing them to live in the apartment. Do you know what she referred to him as?
I don't know what Miss Jasmine referred to him as, because I never directly spoke to her.
Okay, then. But you don't recall Miss Brownlee also referring to Mr. Terry based on Miss Jasmine's indication of him living in the home?
I'm not sure I understand your question. Are you asking if she ever referred to him as Danny Ingram, or are you asking if he lived in the home?
I'm asking whether or not she ever referred to him anything other than Mr. Terry.
I never spoke to her, so I don't know if she couldn't have referred to him as Danny Ingram because we still didn't have his name, and Miss Brownlee did not know that his name was Danny Ingram either.
I guess the question was because she had interaction with Ms. Jasmine as a reporter, reported that his name was Mr. Terry, that they called him Mr. Terry.
Everyone referred to him as Terry because that is what he presented to us.
Okay. And so that if that's his nickname in the street, you don't know.
I don't know.
And the other thing is, was there any indication that he was in the home when Christian was there?
When exactly? Are you saying about visitation?
Yes.
Well, I can't say that he was or was not. I did advise my case managers to perform unannounced visits during these scheduled visitations. However, with the information that was provided to Miss Alicia, and the time frame that the other case was occurring, I would be led to believe that he was there while Christian was there last Friday.
Okay, but you don't know it, and nobody reported.
No, I don't know it for a fact. No.
Never. Correct. That's all I have. Thank you.
All right. Anything else?
One other follow-up question for Ms. Long. Ms. Long, did you also receive, or the department receive, I should say, an email from Christian's daycare provider?
Yes, sir. I did receive an email from a Miss Octavia. She is the director, and I received that email on today.
And did the director report to you concerns about Ms. Tatiana Brown from last Friday, the 12th of April?
Yes, sir, she did. She stated that Mom was different from when she picked him up from when she was bringing him back. She stated that she brought him back an hour earlier than scheduled. During that time, they were asking Mom to put his car seat and his diaper bag into an empty classroom. And in that process, she dropped the car seat and she bumped into a wall twice. She stated to Miss Octavia that, it was her medication and that she had been on medication for something to do with a toothache. It was prescribed by the dentist. But she didn't say the name of any medication. However, she did bump into, according to the daycare director, she bumped into the wall twice and dropped the car seat, and she just seemed uncoordinated and not herself as to what she was when she originally picked him up.
What was the name of the daycare provider?
The daycare provider is Sun.
And what was the name of the individual who made a report to the department?
Her name is her first name is Octavia. I can't recall her first name, but it is in the email that she sent to us on today.
And did that individual report concerns that they believe that the mother was under the influence of something?
She did, but again, she did state that Mom said it was medication from the dentist.
Nothing else.
All right. Is the evidence closed? Well,
as far as the department's questions, Your Honor, but my client wanted me to make a request today while we were here.
Okay.
Is that okay?
What?
Well, I'd reached out to the department, and Attorney Skoranek was not sure. The father is asking the court to consider expanding his visits and allowing him to transition to overnights. I believe the father has maybe spoken to the case manager regarding this, but we just wanted to get the department's position and see if the court would allow that with the department's consent.
So, Your Honor, I did have a discussion with Ms. Crane about half an hour before we had this hearing on that. I reached out to Ms. Long. She said that there's a home assessment of Mr. Murray's home has been done. That is currently pending. It has to be looked at by supervisors to make a determination. And so it's kind of premature to say we're hoping to have that decision as to whether or not his home is approved by the end of the week. Then the department would need to staff as to whether or not they would be in favor of the visitation that Ms. Crane's client is asking for. So I really can't answer that right now until that goes a little bit further along. And I told Ms. Crane we would hope to have some kind of, idea of that by the end of the week.
Okay. I'll just advise Mr. Murray to keep in contact with his case manager then.
May I speak, Your Honor?
Hold on just a second, please.
Yes, sir.
I'm going to give the department till the end of the week to, it seems like the last time we were here, they said they were finishing up a home study on him. So I don't know how long all this takes, but it's going to finish up real quick. So you do what you have to do about your assessment by the end of this week, and you confer with this gentleman and his lawyer and tell him what you found that you're able to do. And we're going to review his expansion of visits, if any, Monday afternoon at 3:00. A special set hearing for him, just like we did for Mom. So,
Your Honor, I cannot do a Monday specially set. I have a TPR hearing in Walton County that afternoon.
Well, it'll go a lot faster without you. So,
may I add something, Judge Bartles?
I don't know. I'm sorry, I don't know who spoke, but
it's Brandy.
It's me.
Okay.
So my thing is, if I've reviewed the home assessment, I just have to present it to Ms. Ishmael and Ms. Thompson for their approval and signature. So what I'm saying is, do we need to come back to court? Can we just
if y'all
move forward?
Finish your assessment, and then you meet with him and his lawyer and say, this is what we're willing to do, and y'all work it out. We need to have a hearing. Y'all just give me a consent order of how we're going to expand his visits. And if they're not in agreement, or y'all aren't in agreement, then I'll have to referee it. And you want to get back here by 6? You think you can be back here by then from Walton County, Mr. Skowronek?
Did you honestly say if you set it for 6?
That's why I said, can you be back by 6?
Well, let's put it this way, Your Honor. Every time I've gone to Walton County and had a hearing, none of them have been any less than 5 hours, and that hearing is supposed to start at 2. So I have absolutely no idea when I'll be back. I finished yesterday at 6:30. So you have run into some lawyers who are as long-winded as you are. So that explains the length of time you're spending over there. Tell me, I don't think I asked him. Let me see what Robin has. Wasn't it Monday afternoon we were talking about? Well, they don't, Mary, she's telling me that you're on leave, but this is mainly Ms. Crane and Mr. Murray. You wouldn't even need to be here. You're welcome to be here, but if you're on leave, you probably don't want to be here.
I just got notice of another specially set hearing on Monday, so I must have just got notice of it. I don't.
Hold on a second. Okay, well, y'all leave it, but I want him to have a hearing next week sometime if y'all don't work it out, okay? And we'll come up with it. And it may be at 6:00 at night. Did I answer your stuff, Mr. Murray, for you?
Yes. Yes, everything. I just wanted to mention one thing that before Ms. Brownlee left, she mentioned to me that should have only been a 90-day process for me to go from unsupervised to overnights to
there's nothing set in stone about how long it takes. Every case is different. I've had people move in 30 days from one to the other, and I've had some take 6 months and longer from one to the other. So don't worry yourself about that. She's just trying to stir up get you stirred. You've been doing pretty well, and you know you have been, and we're going to see what we can do. Okay.
Okay. Thank you, Anna.
Sure. Review of Mr. Murray's expansion of visits request. All right. As to mom, her visits will revert back to supervised. She still needs to see her child, given the age of the child, twice a week. Obviously, they won't be lengthy as they have been when she's been doing them at her house. They will be supervised. Drug screens need to be at least twice a month, if not more. They need to be random. And I feel reasonably, I don't know the gentleman that testified earlier that he recommended level 1 substance abuse treatment for her. I don't know when she was last given a formal drug and alcohol assessment. I don't know, given the current, where it sounds like her mindset is right now, I'm not sure how truthful she would be and how accurate it would be, but she's got to be in therapy ASAP. The department's got to make it available to her. And she's got to do it and successfully complete it. And,
are you saying level 1 or a new assessment?
Well, I can't decide. I had written down I was fine following his recommendation, but I don't know whether we don't need. I mean, if she's had an assessment within a year, this file is thick enough. I think this case is going longer than a year.
I'm pretty sure it's longer than that. I don't have it right at my fingertips, Your Honor, but that's it's been longer than a year.
This started in June of 2021. So,
Judge, we were going to have Miss Brown assist again. That's something that we had already been discussing with Clayton. So she's going to be assist again, and we're going to try and get another provider.
Okay. All right. Get that assessment as soon as possible. It's
yes, sir.
And her following the recommendations of the assessment are also part of the order that she has to do. And hopefully she will. She had come quite a long ways. It's a shame, but that's the nature of addiction. People do well, and then they fall off the wagon, and they get despondent and angry, and all those emotions get in there, and that doesn't help. Most importantly, it doesn't help her to get back on the road to recovery and sobriety. But she's got to do it for these kids. All right. So this is April 24th at 3 on Zoom for Mr. Murray's issue, if the hearing is needed. Like, Mr. Murray, if you and your lawyer work out an arrangement that you're satisfied with, I'm satisfied with it, and you won't have to come to that hearing, okay? So stay in touch with Ms. Crane about all that. And if you're not happy with it, then I'll hear all sides, and then I'll decide.
Okay.
All right. Thank all of y'all for your time. Did I answer the questions you needed answered, Mr. Skronic?
Yes, you did, Your Honor.
Good. Thank everybody for your time. I'm sorry?
Mr. Murray, I'm sorry. I'm going to let Mr. Murray know as soon as I hear from the department, I'll contact you and we'll review the proposal.
Okay, thank you.
Bye-bye. Thank y'all.
Thank you.
All right, thank you.